it hands a lot more power to the executive branch. So does this other major ruling that I also want to get to on the Affordable Care Act. The justices had to decide if this task force that gets to determine which healthcare services are considered preventative and have to be provided to patients at zero cost, whether that task force was constitutional. The justices are saying yes, and essentially that task force is at the complete discretion of the Health and Human Services Secretary.
That's exactly right. And so the challenge in this case was to the composition and the discretion that this task force has to establish rules. So the Affordable Care Act is a massive piece of legislation, but there are a variety of very technical and very specific aspects that the legislation package leaves to the kind of administrative process to implement. This task force is an example of those administrative technicalities that are very, very important to millions and millions of people. In this instance, the task force established a list, essentially a battery of tests and procedures that you are required as an insurance company who participates under the Affordable Care Act to provide at no cost to individuals, no copay, preventative care, screenings, and procedures.
When you go, you get a physical, you walk out of the office, no copay, no nothing.
Exactly. And so this 16-member task force established the list of those procedures that where that policy would apply. The challengers, a group of Christian-based organizations and businesses who felt that this policy was unconstitutional, brought a challenge. The lower courts ruled in favor of the challenge. Today, the court said the constituting of this committee, these task force members, it is consistent with the Appointments Clause of the Constitution, meaning that the challenge to the Affordable Care Act in this regard fails, but that the Health and Human Services Secretary does have a lot of power in terms of constituting that task force.